Welcome to another jaw-dropping courtroom breakdown, and this one, it's chaos in a collar. Today, we're watching the unraveling of a theft case that spirals into explosive conflict, emotional confessions, and legal confusion. Jonathan Cruz is facing serious time, up to 10 years, but it's not just the charges on trial. With a public defender on the verge of quitting and Cruz accusing multiple agencies of botched evidence, this courtroom turns into a battleground of credibility, frustration, and fiery drama. Stay tuned. This gets wild.
What are y'all here on? Or you have something?
It's illustrated on the file.
Oh, okay,
I think December 4.
okay. Well, I don't need you back to one.
He has nowhere to go. He has no life, no friends.
And I have Jonathan Cruz on a withdrawal.
I see. It's Jonathan Cruz.
Yes.
Come on up.
Cruz is in custody.
What are you gonna do?
I'm seeking to withdraw on that case.
Cruz, please, thank you. Okay, you are Jonathan Cruz?
Yes, sir.
24 CR 565 is called. You were charged, as you know, with the state jail felony of theft. And then the indictment goes on to allege you have 2 prior convictions of state jails, and then this state jail felony then becomes a 3rd-degree felony for punishment.
Yes.
If all of this is true, if you're found guilty. And then you're looking at no less than 2, no more than 10 years confinement in prison and a fine up to $10,000. You understand?
Here's where things get serious. Cruz is not just facing a regular theft charge, it's a state jail felony. But because of 2 prior convictions, it bumps up to a 3rd-degree felony. That means he's looking at a potential sentence of 2 to 10 years in prison and a fine up to $10,000. This upgrade is crucial and is often misunderstood. Prior convictions significantly escalate sentencing exposure in Texas. So when the judge asks, "Do you understand?" it's not just routine. That one yes could mean a decade behind bars. Would you be calm in his shoes?
Yes, sir. All right. So here, Mr. Wilkerson has been your attorney. Are you detained on this?
Appointed, Your Honor.
Appointed. All right. Go ahead. You filed a motion to withdraw.
Yes.
Here on August 21st. Go ahead.
Your Honor, so in this case, we have endeavored to satisfy all of Mr. Cruz's requests and representations exhaustively, from contacting parole officers at his request because of a revocation warrant on file.
You do a good job. You are pretty intent on taking care of business.
To issuing subpoenas to phone carriers in a number of other locations. Ultimately, it comes down to a conflict that renders this attorney-client relationship unworkable at this point. There are issues ranging from allegations that the dates on various offense reports or rental contracts or things of that nature are wrong, to even more in-depth issues. And so our last in-person meeting devolved into a loud exchange, Your Honor. I don't know what more I can do in service of representing Mr. Cruz. I believe it's in his interest and the interest of justice that another attorney be appointed to represent him on this matter.
Okay, so what happened? What's the blow up that happened on the last? Because
This is where it all breaks down. The defense attorney, Mr. Wilkerson, explains that their attorney-client relationship has completely deteriorated. He's subpoenaed phone records, investigated parole warrants, even traced cell tower data, but none of it seems to satisfy Cruz. We're hearing about loud exchanges, accusations of dishonesty, and an attorney practically begging the judge to be released. And here's a question for you. When does legal representation become impossible? Should every defendant get a new lawyer just because they're unhappy? Or is there a line where the court says, enough?
I don't expect defendants to be mistreated. And I certainly don't expect my lawyers to be mistreated.
Yes, sir.
That will have severe sanctions. I can hold people in contempt of court because attorneys are going to quit wanting to represent people. And then good luck with the Constitution then if you can't be civil with a person who's working for your best interests. He's saying what he's saying. I don't believe him to be a liar and a man who is dishonest. He's never been that way to me. You can put that away.
This is a document that says that I gave him a number. This is from the emergency response to T-Mobile. He tells me that the company says that is no record of such. And the company, this is a subpoena that says, no, what the attorney gave them the wrong
That is
phone number.
right there.
No, this is the wrong. He asked them to research the wrong phone number.
Okay.
And they saying that he gave them the wrong phone number. So that's not my phone number.
Okay.
And they say it's right
Are
here.
y'all trying to fix that?
It says,
Judge,
please have
the
your attorney
issue-
correct the
Hold on,
target
he's
information.
talking. Let him talk. Go
It
ahead.
says, please have your attorney correct the target phone number and issue a new legal.
Okay.
So they saying that I have a phone number with you.
Okay.
But you
Relax. Relax. Let me look at this. What's the, this is on August 11th?
Yeah.
Okay, T-Mobile hereby objects to the reference legal demand and is unable to respond. Which is not service. Okay. You've seen this.
No, Your Honor, but we issued subpoenas for 2 different phone numbers based on our
Now we're knee-deep in one of the most common defense evidence nightmares, mismatched phone numbers. Cruz insists his lawyer subpoenaed the wrong number, leading to bad evidence. The attorney fires back that he used the numbers Cruz gave him. T-Mobile objects, and the court is caught in a frustrating loop. This might seem like just a tech error, but it's not. These phone records could prove alibis, witness calls, even innocence. A single wrong digit could tank a defense. Whose fault is it? Cruz's for misinformation or the attorney's for failing to verify?
client's representations of what numbers belonged to him at the time. We received one affirmative response, to which we received a list of incoming and outgoing calls. I reviewed that with the client. He insists that other calls were made that are not shown on that record. The other phone number I subpoenaed was the number that was provided to me by my client in a number of different communications. This is just a series
What
of
about that?
ongoing.
Did y'all receive information from the phone company on that?
We were, as indicated, Judge, we received one response with records, and we received another response with regard to the other number that he provided, saying that there were no records associated with that number. There are issues regarding the contract that was executed,
Contract.
allegedly to rent a vehicle.
It's just the basis of this
Which
charge.
serves as the basis of this charge. There are issues regarding offense reports submitted by other agencies to the Department of Public Safety, in which the defendant alleges that the reports contain inaccurate information. It's not a workable relationship, Your Honor, and I would just again urge the court to appoint a different lawyer, perhaps, who might be able to communicate with this defendant in a way that I seem not to be able to do.
Judge Steve said, with all respect, sir, this is what I want. This is what I seriously need. I want him to show you one document from the text dot police, from the text dot division. I was in an accident with Enterprise Run. I was hit in the vehicle.
Here's where things take an unexpected emotional turn. Cruz reveals he survived cancer, has a hip injury, and was allegedly hit in an enterprise rental, with settlement offers from the company reaching up to $230,000. But instead of joy or resolution, there's visible pain, confusion, and desperation. He feels the criminal charge is overshadowing what should have been a life-changing payout. This is the kind of moment that reminds us people's lives don't pause because they're in court. Pain, recovery, and justice are all tangled here. Would you trust the system if this was your story?
In the text dot report, the text dot report is wrong. It says on that document, if an officer was on arrive, if a Dallas police officer arrived at this scene, then what is their final conclusion in the narrative? It says that an officer is flagged down, which means I called Dallas police, which means Dallas police to have a police report. He's going to text dot instead of Dallas police. You have Dallas County Sheriff that recovered the vehicle, and then you have Dallas police who actually wrote the dude that hit the Enterprise rental car called driver side and passenger side damage to the car. I had counsel, I had a beat counsel in here, and I had a left hip injury. I'm trying to get. Then he tell me this: Enterprise rental is offering me 170,000. I told him no. Then he say Enterprise rental is offering me 230,000. I told him no. You more important. You more worried about the civil instead of criminal. For them to be offering me something like that, let me get on the streets. I'm not absconded. I can go get my own records, and I will show you. That's why I'm asking. Can you please let me see that take that report so I can present this to Judge Stevens?
So,
Okay.
as
What do you
can-
say to that?
There is a text dot report that comes from the Department of Public Safety
Huh.
regarding the accident that took place in Dallas. The report date on the report is from August 24th, I believe, of 2023. I believe the state also has a copy of that document. It was submitted with the
What was the day of the report?
The day of the report was August 24th. It was in the documents that
So
came
that's
from.
before this event occurred.
No, Your
The
Honor.
indictment. The indictment says on or about October 2nd.
Oh,
This
it's
crime
fine.
occurred.
No, okay, so
Yeah, I've seen that
the
picture.
offense report was made in October, but the offense itself,
Take your time.
the initial rental took place on August 17th of 2023, which the defendant also indicates or alleges is an incorrect date. And again, Judge, I mean, I don't even know where these numbers about hundreds of thousands of dollars are coming from.
So look,
With all
Look,
due respect, Judge
yeah.
Stevens,
with all
this is my first
respect,
time ever in life bringing the rental car. This date happened August 13th. I came back down here.
the facts don't have a lot to do with me unless you want to go to me for a trial. You want a jury trial. It's for the jury to decide what the facts are. Right here, what I want is a defendant and the attorney to work together unless you want to represent yourself.
That's another issue, Your Honor.
Is that right?
He alleges that he is entitled to hybrid representation. Judge, this is the offense report.
Judge Stevens, it says
I don't need
right
to see
there.
it.
This-
Hey, yeah,
So
you know what?
Damn.
You know
So that
what?
means that it's a Dallas police report, and he refusing to go get it. That's
Sit over there. You're in timeout, Mr.
It's
Rude.
right and wrong.
You're in timeout, Mr. Rude.
And here it is, the moment it explodes. Cruz talks over the judge repeatedly, challenges his rights, and is held in contempt. The courtroom shifts from debate to discipline. Judges have the power to jail someone on the spot for contempt, and that's exactly what happens. Why? Because order matters. Without it, justice turns into noise. But here's a tough question. Was the judge too harsh, or was this the only way to regain control? Let us know. Who do you think crossed the line first, Cruz or the courtroom?
My goodness. No. But we learned in first grade, don't speak over other people like you're doing to me. You want me to hold you in contempt? I can put you in contempt, and that would add time to whatever this is. Don't be rude. Don't be rude. I just said, you're going to have.
When you tell me I don't want to see that, You refusing my rights.
All right.
That's what you gotta do.
You're held in contempt. You are now placed back in jail until you can act properly, Mr. Rudeness.
I have a right to
Mr. Rudeness, go back inside. Thank you. All right. Yeah, well, you got your work cut out for you. What do you want to do?
I would like to withdraw from the case, Your Honor. The change that the defendant initiated with the court just momentarily is illustrative of every exchange that occurs in person between myself and the defendant.
Well, why would it be any different with anybody else, do you think?
Well, I have to believe that there is someone out there who can speak this defendant's language and make him understand.
English. Although it's a rude form of the English. All right, who's next on the trial? All right. All right, I'm gonna grant you relief. Put you out of your misery. But from time to time, we have obstreperous clients. They're very difficult, but maybe another one will be have some better results from his responses, because he's obviously angry, and he certainly acts rude, and he certainly wants to control the situation on his terms, which is not the way the rules of evidence and the rules of law work. Everybody gets a fair opportunity to be heard, including him, but he can't overpower everyone else and try to control the proceedings by speaking over everyone and shouting. So hopefully, next person on the list will be appointed to represent Mr. Cruz, and I allow Mr. Wilkerson relief. He is requesting.
Thank you, Your Honor. Excuse?
Yes.
So, what just happened? Jonathan Cruz, facing a felony theft charge, lost his lawyer, not due to law, but to conflict. The court granted Mr. Wilkerson's withdrawal and will appoint new counsel, hoping someone else can bridge this communication chasm. From phone records to accident reports and emotional outbursts, this wasn't just a legal case. It was a collision of distrust, pain, and frustration. And the bigger picture? This trial hasn't even started yet. The jury will eventually decide the facts, but today showed just how messy getting to trial can be. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.